Carney's Crime Crackdown, Canada brings back tough bail and jail laws. Welcome back to Canada Chronicles. Across the country, a major shift is unfolding in Canada's justice system that could redefine how crime and punishment work in the years ahead. The government has announced plans to bring back tougher bail and jail laws to keep violent offenders off the streets and rebuild public confidence and safety. But beneath the headlines lies a deeper story, one about crowded courts, overworked jails, and the struggle to balance community protection with individual rights. In today's video, we're breaking down what these reforms really mean, who they'll affect, why they're happening now, and how they could transform your province's justice system. Stay until the end, because we'll reveal how this crackdown could change your routine, your rights, and your neighborhood in ways most Canadians haven't yet realized. If you haven't already, subscribe and turn on notifications so you never miss a critical update on Canada's immigration and policy changes. Let's get started. More people accused of serious crimes will soon remain in custody before trial, and those convicted of multiple violent offenses could serve longer, back-to-back sentences. That's what the federal government says its new crime bill will deliver. If passed, these changes will reshape bail courts and provincial remand centers long before they appear in campaign ads. The promise is safer streets. The risk is an overloaded justice system. And the battle over where to draw that line is already building in Parliament. A turning point for Canadian justice. The Prime Minister's office says the bill will introduce reverse-onus bail for major crimes, consecutive sentencing for multiple convictions, stricter conditional sentence limits for sexual offenses, and tougher penalties for organized retail theft. In simple terms, people accused of violent crimes will have to prove why they deserve bail instead of the Crown proving why they should be detained. The target list includes violent auto theft, break-and-enter, human trafficking, assault, sexual assault, and violent extortion. This isn't a blanket rule for every charge. It's an expansion focused on repeat offenders and crimes that cause widespread harm. But the practical effect is clear: more contested hearings, longer waits, and heavier pressure on legal aid lawyers and provincial jails. Building the muscle. Ottawa is pairing the plan with $1.8 billion over 4 years and 1,000 new Royal Canadian Mounted Police officers to strengthen investigations into organized crime, cyber exploitation, and money laundering. The government says stronger laws require stronger enforcement, though hiring and training that many officers will take time. Criminal law is federal, but the daily work, bail hearings, detention, and transport falls to the provinces. If pretrial detention rises, provinces pay for extra cells, staff, and health care. Without new funding, court delays grow and jail conditions worsen. That's where this reform could either succeed or fail. Visible consequences. Picture the same officer arresting the same person 3 times in a year, this time for a violent offense. Under the new rules, quick release on bail becomes unlikely. Now imagine a judge sentencing someone with multiple serious convictions. With authority to stack sentences, that person could serve every year consecutively. For communities hit by repeat crime, this feels like long-awaited accountability. Yet more people behind bars also mean higher costs and overcrowded facilities. When capacity shrinks, rehabilitation programs vanish and justice slows. What changes and what stays? Reverse-onus bail changes who must prove the case, not the basic rights protected under the Canadian Charter of Rights and Freedoms. Judges still decide whether community safety outweighs personal liberty. Consecutive sentencing will not apply automatically. Judges must justify when time should stack. Conditional sentences, often known as house arrest, will be restricted for certain sexual and violent crimes, but remain for lesser ones. This reform fine-tunes discretion instead of removing it. Rights, restraint, and real data. Groups such as the Canadian Civil Liberties Association warn that Ottawa still lacks national bail data, showing how often accused people reoffend or which conditions actually work. Expanding reverse-onus rules without that evidence, they say, risks eroding the presumption of innocence. The Conservative Party of Canada argues the government should scrap the federal principle of restraint, which tells judges to use the least restrictive bail conditions possible. The governing party counters that restraint should stay for low-risk offenders, while tightening rules for violent ones. The outcome will depend on how Parliament writes the final bill. Lessons from the past. Reverse-onus provisions already exist for the most serious crimes and were expanded in 2023 for repeat violent offenders and intimate partner violence. The current proposal builds on that foundation, extending it to more offenses seen as high risk. It's a continuation, not a revolution, in Canada's push for tougher justice. Voices from the North. Northern leaders have cautiously supported stronger enforcement while calling for fair, culturally aware implementation that respects Gladue and Ipoli principles for Indigenous offenders. They stress that housing, addiction treatment, and youth support must grow alongside punishment, or the cycle of crime will continue. True safety, they say, requires prevention as much as prosecution. What it looks like on the ground. A repeat offender charged with violent auto theft will now face higher hurdles to secure bail. Their lawyer must present a verified address, strict curfew, and financial sureties willing to supervise. Any weak point could mean detention. In a human trafficking case, consecutive sentences could reflect each act's separate harm. A sexual assault conviction that once might have earned house arrest would now mean jail time. Each example delivers a stronger consequence, but also adds strain to the institutions that must carry it out. On the other side, a first-time accused person with a steady job could still be detained under tougher defaults. Lawful pretrial custody can ruin employment and housing even if the person is later acquitted. The charter guards against unlawful detention, but lawful detention can still destroy stability. That's why narrow offense lists and well-resourced hearings are crucial. The missing dashboard. Analysts say Canada needs a public bail data system showing national release rates, reoffending numbers, and regional trends. That transparency would let lawmakers measure whether reforms cut violent crime or simply shift the burden from the streets to the jails. Without data, policy risks chasing headlines instead of results. What to watch in Parliament? Watch the final offense list. Narrow lists prevent overreach, broad ones flood jails. Watch whether judges must explain consecutive sentences on record. Watch for funding to provinces that operate remand centers and legal aid programs. And note the effective date. New laws change little until provinces update procedures and training. The gap between public expectation and legal reality could be months long. The government will face pressure to show results quickly, even while the system adjusts. Thanks for staying with us this far. We appreciate your time and hope you're finding this information valuable. How this crackdown could change your routine, your rights, and your neighborhood. Start your morning passing a shopping plaza. Soon you might see more police operations targeting organized retail theft. Undercover teams, cargo checks, and quicker arrests. That may bring relief, but theft could move into smaller shops or online resale markets. If you work in healthcare, education, or social services, you'll feel the ripple effects of longer remand stays, missed appointments, disrupted families, and heavier caseloads. Legal aid lawyers will craft more detailed release plans with verified addresses and treatment intake forms. In the evening, communities hit by repeat break-ins or assaults may finally see change. Accused offenders will face stricter bail rules and longer sentences if convicted. But success depends on every part of the system working together, from police and prosecutors to correctional officers and community programs. If supervision programs, transport, or facility space fall short, the system will strain. Real safety requires both enforcement and prevention. Mental health care, addiction recovery, and stable housing. Without that balance, the cycle returns. Where this could land. The Liberal Party of Canada will defend the reforms as a balanced response. The Conservative Party of Canada will push for tougher measures. Civil rights advocates will test constitutionality, and provinces will demand funding. Big cities plagued by auto theft and trafficking will feel early effects. Smaller regions may struggle to manage higher remand numbers. If Parliament keeps the offense list focused, funds provincial systems, and requires clear judicial reasoning, these reforms could cut violent crime without breaking the justice network. But if the law expands too broadly or budgets lag, jails will overflow with little improvement in safety. Safety by design, not by slogan. The government's goal is clear: keep serious offenders off the streets and give law enforcement the tools to stop them. But strong laws mean little without strong systems to enforce them fairly. To succeed, Canada needs guardrails, clear offense definitions, transparent data, real provincial funding, and judicial oversight that upholds the Charter. Done right, Canadians could see safer communities without losing fairness. Done poorly, the country could trade one crisis for another. The reforms we've discussed show Canada entering a new era of law and order, one that promises security but demands balance. The true test won't be in Parliament. It will unfold in courtrooms, jails, and neighborhoods across the country. Whether this crackdown restores trust or reveals new flaws depends on how well justice and compassion are balanced. If you found this video informative, like, share, and comment below. Do these tougher laws make you feel safer, or do they go too far? Let us know, and don't forget to subscribe and turn on notifications so you never miss our next deep dive into Canada's biggest policy stories. See you in the next video.